Hello, everybody, and welcome to 2025. We are thrilled to be back with you. I am personally delighted to be hosting. It has been a little while since last I was with you, November, in fact. But since that time, you've been in good hands with Adam Mastroleo and as well with Kristen Smith. We, of course, took a bit of a pause during the holidays. So we're hopeful that all of you who tune in regularly both got the word and as well, more importantly, enjoyed the bit of break that all of us deserve. And so we are here, though, as 2025 commences to keep this program moving forward and, of course, available for all of you, our loyal listeners and participants. We're just so glad to have you back. Let me, with the next slide, please, Kathy, walk the group through what we're intending to cover here. And if you can go just one further, there we are. Thank you. I'm here in New York City. Glad to be hosting you today where it is really cold. We are getting the tail of that massive storm that has crisscrossed the country in the last 36 hours. But the rest of the presenters are in even colder Syracuse at the moment, and they will be as follows. Alyssa Christian is going to be addressing the Corporate Transparency Act. There's been some movement there since we last had a presentation on it. Tom Iran, who is well known to all of you, is here to talk about some NLRB activity we think is relevant. Ksenia Primo is back as well on the program to talk about immigration matters that are similarly topical. But before we get into the presentation, let me quickly walk you through some updates and changes. If you go to the next slide, please, Kathy. So what's new in 2025 is that we will be having our regular format at noon Eastern, as you've come to know, but we will be keeping to a peppy, as it were, 30 minutes rather than the 45 that we had previously. So you can plan on 12 to 12:30 going forward. We will also continue to roll in topics on specific issues or areas of focus. We will separately let you know and promote them as we've done in the past. So just pay attention to your emails and you'll learn more about that. We, of course, had some of those in the fall of just last year, and we were delighted to see so many of you turn out. More of those to come. And as we move further into this month of January 2025, we're going to be looking back at 2024, peering ahead into 2025, as we've done in January's past. Today, we'll be doing that informally through our presenters, and we will have more formal programming as we dive into the rest of this month ahead. But let me give you a quick update on the next slide concerning some governmental activity that I just want to make sure all of you have in mind. Of course, we know that we will be having a change of presidents, and President Trump will be beginning a second term as of January 20th. The results were certified in Congress just yesterday in Washington, D.C. So you can expect plenty of coverage on those federal activities that affect all of you in the coming weeks and months. And in New York State, we will have a deeper dive over the course of the month on 2024 end-of-year bill signings that Governor Hochul either undertook or didn't. There were some bills vetoed and otherwise, but we'll get to that later this month as we roll it into our coverage of what is going to be the executive budget proposal in the state of the state, which is upcoming as we move into mid-January. Important headlines in the in-between. We did see the so-called MCO tax, managed care organization tax approved, which is about $2 billion that is going to be coming into New York State, as expected anyway, through approval by the federal government. It's an accounting maneuver, as it were. California also has benefited from this, and CMS signed off on this just before we flipped into 25. We also here in New York City are in the early days of congestion pricing, which finally got approved after lots of debate and conversation that we've kept you all apprised of. And that will be another revenue driver if the program stays in place. There's still plenty of litigation and effort to see whether that does hold. So without further ado, and knowing that, again, we have a crisp 30 minutes, 25 yet ahead, I want to introduce our first of 3 presenters today. The first is Alyssa Christian. Alyssa is back with us on the program. We're delighted to have Alyssa. Alyssa is going to provide updates on the Corporate Transparency Act, which has been, for lack of a more elegant term, a bit of a yo-yo in terms of what it is and isn't with enforcement. There's been a lot of federal court activity. All of you may well have received notices from Bond about some of this, and we just want to give you the latest because it matters to many of you, and Alyssa is here to help. So Alyssa, welcome back from our Syracuse office. We're thrilled to have you, and the floor is yours.
Thanks, Gabe. Hi, everyone. So as Gabe said, I was here a little over a month ago and essentially begging everyone to please prepare and file their beneficial ownership reports because of that deadline that was January 1st, 2025 for most reporting companies. Literally a few hours after I gave that presentation, there was a universal injunction issued against the Corporate Transparency Act, which meant that reporting was not required, and it was uncertain whether it ever would be required. Reporting requirements did briefly come back right before Christmas, but if you blinked, you missed it, because as of right now, the Corporate Transparency Act is on hold again. So today I'm going to go through what happened and where we're going from here. So on this slide, I have outlined what the Corporate Transparency Act timeline was supposed to look like. On January 1st, 2021, Congress passed it, and notably this was over Trump's veto. On January 1st, 2024, that's when reporting requirements went into effect. So here at Bond, we started filing reports for newly formed entities, and we were preparing to file for the existing reporting companies by January 1st, 2025. As I mentioned, we did not make it to that January 1st, 2025 deadline. And as you'll see on the next slide, what happened there. So as I mentioned, it went into effect really on January 1st, 2024. We knew that there were lots of challenges to this law, and there was the possibility of injunctions. However, personally, by the end of the summer, when those injunctions just did not come, I didn't think it was going to happen at all. So we began really getting to work preparing for that January 1st, 2025 deadline. But on December 3rd, a district court in Eastern Texas issued a universal injunction putting the CTA on pause. So as I mentioned, this meant that reporting was not required. On December 23rd, 2024, the Fifth Circuit motions panel issued a stay of the injunction, which meant that reporting was required. Now, when that was ordered, the deadline was still January 1st, 2025. So it looked like there was going to be a really quick turnaround. Thankfully, the government came out and extended that deadline. However, 3 days later, a different panel of the Fifth Circuit then issued another stay of the injunction, meaning that reporting is not required. So following that, the Department of Justice has now asked the Supreme Court to issue a stay of the injunction, which would allow reporting to occur while the Fifth Circuit determines the constitutionality of the CTA. So this back and forth had nothing to do with the constitutionality and more to do with whether the injunction should be in place while the constitutionality is determined. So it's more procedural. On the next slide, I just outline what is going to happen now. So as I mentioned, the Department of Justice has asked the Supreme Court to issue a stay of the injunction. The Supreme Court has asked for responses to be submitted to that by the end of this week. Therefore, it's likely that the Supreme Court will issue a decision regarding the injunction probably sometime next week. While that's happening, the Fifth Circuit is accepting briefing for the constitutionality issue. And that will wrap up in March when they have oral arguments on March 25th. And then sometime after that, the Fifth Circuit will issue a ruling on the constitutionality. And regardless of the decision, that's likely going to be appealed to the Supreme Court. So another change could happen then. As I've mentioned, this is really uncertain. We don't know when these decisions are going to come or what they will be, and what the timeline for reporting would look like if the injunction is lifted. So on the next slide, I just have some points about going forward. As I've mentioned, right now, there is no reporting requirement, but that being said, the website to submit your BOI reports is still accepting new reports. So we can prepare and file if you choose to do so. Again, we don't know if there will ever be a requirement to do so again, so you might want to hold off. But if you haven't actually started preparing for it yet, given the fact there might be a quick turnaround, it's always a good idea to be familiar with what the reporting would look like. So if you haven't done that already, please reach out and be happy to discuss that with you. And please, stay tuned with everything changing on this. I'm happy to help.
Alyssa, thank you for that quick recap. And as you point out, so much of this is fluid. So we will be coming back to all of you as audience members to keep you apprised. Let me now introduce our next speaker for the afternoon here on the East Coast. That's Tom Iran, well known to all of you as a member of our labor department and formerly its leader, and who has been on the webinar innumerable times to talk about various issues of concern. We are happy to have Tom back to talk about NLRB activity that Tom thought was fit for this audience, and I'll let Tom introduce it further. Tom, the floor is yours, and again, welcome back.
Thanks, Gabe. Good afternoon, everybody. Welcome from snowy Syracuse. We've talked before about the aggressive nature of the NLRB under Biden, and one area where they were particularly aggressive is in the remedy section. And Kathy, if you could go to the next slide, that'd be great. So 2 years ago, we had the Thrive decision, which was the labor board's attempt to expand the ability to collect additional remedies under the statute. One of the frequent criticisms of the National Labor Relations Act by the union movement and those who support unions is that the remedy section is limited. It is not of the same nature as, say, Title VII, where remedies can include not only equitable remedies like reinstatement, but also compensatory damages and punitive damages. And for a long time, union supporters have pushed to expand the remedies available under the National Labor Relations Act. In fact, that was one of the key features of the so-called PRO Act. That's a statute that has never passed and is unlikely to pass, but was designed to put in place through legislation more emphasis on the remedies. And the thinking behind this is that the penalties that currently exist are not strong enough to deter employers. This is the theory, this is the argument, from violations of the statute. So we need a more robust remedial system. And the Biden administration went about as far as they could with this Thrive decision, finding that in addition to the typical back pay, they would provide as a make-whole remedy all direct and foreseeable pecuniary harm that the individual suffered. And Kathy, if you go to the next slide, the Labor Board and the General Counsel have done everything they can to avoid describing this as compensatory damages, but that's essentially what it was. And they, in the case where they found a violation and ordered reinstatement, not only would they direct back pay, but they would look for other monetary harms that the individual suffered, the additional costs associated with the replacement job. If the individual had to take money out of their retirement account and therefore lost the value of that investment, that would also be tacked on as a part of the remedy. And what has happened over the last 2 years is it has made settlements very difficult because of this piling on of remedies, and also has complicated the compliance stage of the litigation. After you have the board decision that's confirmed by the court, you go through a separate proceeding on determining, well, exactly what is the remedy. So this is what we've been dealing with for 2 years. And Kathy, if you go to the next slide, we get a little relief. There's been a great deal of litigation before the labor board involving Starbucks as the union has pushed to organize those locations across the country. In this one particular case arising out of Philadelphia, Starbucks had terminated 2 baristas who were prominent in the union organizing. Charges were filed with the labor board. Not surprisingly, the labor board found that the discharges were unlawful. Starbucks took the case to the Third Circuit. Given the current standard of review, the circuit court deferred to the board on this issue of whether there was a violation of the statute, and so upheld that finding, but rejected the board's position on Thrive and the remedy that it had issued in this decision. So Kathy, if you go to the next slide, here's the core of this, right? The statute, the National Labor Relations Act, has a very narrow definition of what action the board can take following a finding of a violation. It can order affirmative action, including reinstatement with or without back pay, that will effectuate the policies of the act. It's not the same sort of general authorization to award damages to the impacted individual. So we can flip to the next slide, Kathy. And the court here was unwilling to defer to the board and relied strongly on the statutory language to say the Biden board had overstepped, and its authority is limited to reinstatement and sort of the general legal concept is restitution. Put the individual back in the position that they would have been in as a result of the employer's conduct. So it's not all the miscellaneous costs associated with having lost their job and had to spend additional monies. It's what the employer took away. So classic example would be reinstatement with back pay if there were retirement plan contributions that would have been earned in that time. Those can properly be part of the relief. But the ancillary compensatory damages that the board has pushed over the last 2 years are no longer recognized by this court. And there's an interesting constitutional issue here that you may well have heard about, that when an administrative agency is awarding damages, is that a violation of the 7th Amendment right to a jury trial? And because the court could rely on the statutory language, it didn't see a need to get into that constitutional question. But that question is still percolating out there in the context of the National Labor Relations Act and other administrative regulation. So we can go to the last slide. Thanks, Kathy. So because the court rejected the board's remedy, it remanded the case to the board. And as we've talked about, with the incoming Trump administration, we expect a radical change in the makeup of the board and the philosophy of the board. And it seems to me this becomes a good vehicle neatly set up for the Trump board to take a look at Thrive and make some changes, maybe completely eliminate the board's approach on the remedies. It's also a good example of a little bit more judicial activism here, holding administrative agencies accountable. We've seen that in several Supreme Court cases. We see it here. It is important to recognize this is a Third Circuit case, so it is relevant to employers in Pennsylvania and in New Jersey, in precedential in the Third Circuit. It is not. It doesn't eliminate the labor board's position. It doesn't automatically change the rule of law across the country. That takes the Trump labor board to do that, or an appeal to the Supreme Court, which seems to me unlikely. So for those of us outside of the Third Circuit, we need to recognize this is a valuable arrow in our quiver when we're arguing cases, whether it's in the settlement context or making sure that we're litigating the case, we've got the proper defense in place. So it's a significant move in the right direction, and it sets up an opportunity for the Trump board to put us back in a position that's consistent with the statute, limited remedies, and limit the authority of the board to issue remedies. Thanks, Gabe. That's what I had to report.
Thank you, Tom. And we'll see whether, as we move into 25, consistent with my comments at the top of the program, if this comes to fruition. And Tom, we would love to have you back on the program to keep the audience up to date. And we thank you as always. And let me move to our final presenter for the afternoon, who's Ksenia Primo. Ksenia has been on our program a number of times over. Her practice involves immigration as well as several other labor and employment dynamics, but she's going to be speaking on H-1B program updates that are relevant as we move into the new year for all of you who are wearing your employer hats as you tune into this discussion. So Ksenia, please let us know what it is that is important and timely. We look forward to the presentation.
Thank you, Gabe. Good afternoon, everybody, and thank you for joining us today. I wanted to take a few minutes to provide some highlights of the newly implemented rule which impacts the H-1B visa category. Next slide, please. And just the brief introduction of the rule, it was released by the USCIS on December 18, 2024, just a few weeks ago. And the goal of the rule is to modernize the H-1B process, improve efficiency, provide new benefits, and enhance integrity. And I'm happy to report that after reading through the regulations, overall, the changes that have been implemented are favorable to the employers and the employees. We are rarely able to say that, but I think overall, those changes are good, and we will go through them one at a time. Next slide, please. All right, so the new rule will become effective on January 17, 2025, so it will be effective in 10 days. One big thing to keep in mind is that with respect to this rule, the new Form I-29 will be required. So when we file H-1B petitions, we file them on the Form I-129. What is a little bit challenging in this case is that even though you can see the form available in draft form on the USCIS website, it has not been released yet. And unlike in other cases, we are not provided with any grace period in this case. So be very careful when you file in your I-129s. If you're filing it after January 17th, make sure that you're using the right version. Otherwise, your H-1B petition will be rejected. What is a little bit difficult is that typically when we draft the H-1B petition, it takes 2 to 3 weeks to finalize and file everything. So if you started your I-129 petition on the old form, make sure that when you're submitting it, the form has updated automatically, or you've implemented the software that requires the updated form. Another change that this rule is highlighting is that USCIS will have expanded authority for conducting site visits, and we'll talk about that in more detail later in the presentation. And it also changes timeframes for the H-1B cap gap extension, which is available to students. Next slide, please. All right. So this rule highlights a couple of things that, we're all very familiar with, such as if you're filing an H-1B petition, the position must require at least a bachelor's degree, and the degree must be in a specific field of study directly related to the job duties. So one beneficial change is that the language was removed from the proposed regulations, which would have made it impossible for the employers to file H-1B petitions for positions which require just a general degree, such as liberal arts degree or business administration degree. Those petitions were problematic in the past because a lot of adjudicators took the position that those degrees are not specific enough. So with the revisions to the rule, now the adjudicators are directed to focus on the degree itself and the classes that the person took in connection with the degree, and evaluate whether there is a direct connection between the classes and the position, instead of just focusing on the degree itself. So it definitely opens up the filing of the H-1B petitions for, more positions, and provides us with some good arguments to the USCIS. Where we specify more than one acceptable field of study. For example, if we say, we'll take degree in mechanical engineering, systems engineering, or industrial engineering, we need to be prepared to show that each of those fields are directly related to the job duties. Another significant update is that the regulations make it clear that the degree it needs to be normally required, but we don't have to prove that it is always required. So because sometimes USCIS would deny the petition, saying that the Occupational Outlook Handbook says that the degree is normally required. It doesn't say that the person must have degree in all cases. So this makes it clear that the bachelor's degree must be normally required, not always required for the position. Next slide, please. All right, so this one is about eliminating the specific itinerary requirements, and some of you may be familiar with those. Can be very burdensome to provide a detailed itinerary for folks that work, for example, medical professions, right? For example, residents that rotate from one medical facility to another medical facility. In those cases, we had to provide detailed itinerary showing where the person is going to work pretty much, every day for the next 3 years, and that was really burdensome. That requirement is removed. We don't have to provide a detailed itinerary. We still have to provide enough information to show that there is, the true employer-employee relationship between the parties, but we don't have to show where they're going to be every day of the week for the next 3 years. So that's definitely beneficial. Next slide, please. All right. So this particular rule also provides for greater authority for site visits. And what's interesting is that, as you may know, a lot of employees are working remotely from home. And when that happens, we enter their home address on the labor condition application as an additional work site. So now USCIS has authority to go to personal residences of the employees to verify that they actually reside there and that they're working from that particular work site. And non-cooperation can lead to petition denial or revocation. Next slide, please. Another very good change provided by the rules is that the cap gap extension that is available to the F1 students is longer now. So if you recall, when we file an H-1B petition for somebody who is on an F1 OPT or STEM OPT, and let's say the employment authorization expires before the H-1B petition becomes effective, in those cases, as long as we timely file the H-1B petition, the employment authorization was automatically extended through September 30 of the fiscal year. Now this extension becomes much longer. Now it's extended until April 1 of the fiscal year, or the petition start date, whichever is earlier. So that's a really, really good change. And I think it was implemented because USCIS is realizing that they cannot get through all of those petitions that get filed in April, May, June in a timely manner. And therefore they have extended the automatic cap gap extension for the students, so they don't have to leave the country and, suffer interruption to their employment. So that's a really good change. Next slide, please. So what can you do at this point to prepare for these changes? I think it's very important to make sure at this point in time that you're using the right version of the I-129 form, because if you don't, the consequences can be pretty disastrous. So just we need to make sure that we're filing the updated forms. And definitely, I probably sound like a broken record, but if you haven't done so yet, I would definitely recommend reviewing your I-9 forms and making sure that they are in compliance, because we do expect a lot more site visits from this current administration, incoming administration. Thank you.
Yeah, thank you. That was really useful background, particularly as we move into a change of federal administrations. And so we're really grateful for you keeping the information fresh and topical for our audience. So we are at 12:32 actually here on the East Coast, 2 minutes over our allotted 30 minutes, which we thank you for sharing with us. And of course, if there are questions, we will answer them, whether directly now or otherwise by email. You see the slide over here with all of the email addresses of today's speakers. Next Tuesday on the 14th, Kristen Smith will be back with you as host, and we will, as I mentioned, move into our January programming, looking back at 24 and ahead at 25. More details to come. In the interim, thank you all for returning to the program as you have as we kick off 2025, and we're delighted to share this next year with you on Tuesdays at noon here on the East Coast. We thank you for your loyalty. Have a good day.